Welcome to the Mad for Law YouTube channel. Today I'm going over a very important change to the law as of June of 2025. There's a California Court of Appeals case that came out called Eshagian versus Cepeda, and it changed the requirements for eviction notices across the state of California. This applies to 3-day notices to pay or quit, 60-day notices, 3-day notices to cure or quit, all kinds of eviction notices. The California Court of Appeals decision came out June 26, 2025, and it caused major changes to eviction notices in the state of California. The contents of eviction notices is usually the crux of an unlawful detainer case. So making sure that these notices do not contain defects, or if you're on the tenant side, making sure to point out these defects is critical. Due to the court's findings in Eshagian versus Cepeda, eviction notices must now include a very important new element. The court in Eshagian versus Cepeda found that the 3-day notice to pay or quit in question in that case was defective because the notice did not state when the period commenced or ended, and it did not inform the tenant that the 3-day period excluded weekends and judicial holidays. So the court here is very concerned with a tenant reasonably being able to determine when the deadline is for the eviction notice. And the court is essentially saying that without the date that the notice is served being stated on the notice, it's very hard, if not impossible, for a tenant to determine when the eviction time period has lapsed. The court specifically noted that without the notice stating the date that the notice was served, an ordinary tenant would not have reasonably understood when the deadline is. And they wouldn't have understood that if they didn't reach that deadline, that they would be forfeiting possession of the property. This defect can be very simply cured, but landlords are still screwing this up, and they are not including this detail. So this is extremely important for landlords to listen to, as well as tenants, so that they can point out defects in the notices that they're served. Landlords, if you make this mistake, you will lose the entire case, meaning you will have to dismiss your unlawful detainer case. You will have to redraft an eviction notice. You will have to pay the process server. You will have to send the notice to the process server and have the process server serve the tenant. Then you will have to wait until the eviction notice expires. And then you will have to file the unlawful detainer case all over again. And remember that if there is an attorney fees clause in your lease agreement that says that the prevailing party gets their attorney's fees covered by the losing party, then you as the landlord may have to pay the tenant's attorney's fees due to you filing unlawful detainer case based on a defective notice. Tenants, you need to raise this argument to make sure that the judge notices this defect. You need to state it in your answer to bring it to the judge's attention. This will also help you in negotiating a settlement. The eviction notice should state the date that it was served on the first page of the eviction notice. That is what I am telling my landlord clients. That way, it cannot be argued that the tenant could not determine when the eviction notice expired. If you are a landlord hiring a process server or property manager to serve the notice, and you're not sure which day they are going to serve the notice, I suggest leaving a blank space for the date. And at the top of the page, on the first page, it should say, this notice was served on blank date, and instruct the process server or the property manager to fill in the day, month, and year. You can also list the date that the eviction notice expires, but this isn't necessary, and this would require some additional planning since you would need to know the date that it's going to be served in order to know the date that it expires. And you also need an attorney to help you determine when the deadline is for the eviction notice. This new rule applies to all eviction notices, not just 3-day notices to pay or quit. It's 3-day notices to cure or quit, 60-day notices, and everything in between. Forfeiture warning. The court in Eshagian also seemed concerned with the tenant receiving an eviction notice that made it very clear that they would be evicted if they did not comply with the terms of the notice by the stated deadline. The notice must explicitly state that failure to pay by the expiration date or failure to otherwise comply with the eviction notice, such as by curing a breach of the lease terms, will result in the tenant losing possession of the property via a lawsuit, an unlawful detainer case. I recommend using a sentence such as this. If you fail to pay the rent within the 3 days provided, you will be evicted and required to vacate the premises through an unlawful detainer proceeding. That way, I'm making it clear that if you do not comply with the terms of this notice, you will be evicted. And I explained that that eviction proceeding is called an unlawful detainer, and that they will be forced to vacate the premises. Just in case the tenant doesn't understand what forfeiting possession means, it's more clear to say that they will be forced to vacate the premises. So I suggest using that language or both, making it repetitive. There's nothing wrong with putting this warning in a few different ways. You want to make it painfully clear to the person reading it that even for a person without a legal education or any education whatsoever, that they are able to determine that they have to comply with the terms of this notice or they will lose possession of their residence or commercial property. And I like to also mention that they will be subject to a lawsuit, comma, an unlawful detainer, because I like to make it clear that an unlawful detainer is a lawsuit, because some people don't understand that. Address for rent payment. The court in this case also clarified this requirement that we already knew about, but these are some important requirements to go over for 3-day notices to pay or quit. The address where rent can be paid cannot be the leased premises itself. So if the leased premises is 555 Main Street, then the 3-day notice to pay or quit cannot say that the rent owed has to be paid to 555 Main Street. It must be a separate property, and it must be a separate property where a person is available to be paid on certain days of the week, certain hours of the day. It must state their address, their phone number, the hours that the person is available, and the days of the week that the person is available. So it cannot be a P.O. box because a certain person is not available to be served there. It basically has to be to a person who can be physically located. So it cannot be a P.O. box and it cannot be paid to an entity. It has to be a human being. This is really important because essentially these eviction cases based on non-payment of rent all center around one thing. Did the tenant comply with the 3-day notice to pay or quit? Did the tenant pay the rent as instructed in the specific instructions in the 3-day notice to pay or quit within those 3 days? If the tenant failed to do that, and if the notice is not defective, then the case is over. And by the way, even if there is a habitability defense, which means that the property is not suitable for humans to reside in. For example, there isn't hot water, or there's a cockroach infestation, or there's mold. Almost always, the judge will end up ordering the tenant to pay the rent that was owed, subject to a deduction based on what the judge thinks the reduced value of the property is. So even if a tenant is failing to pay rent because there's a massive cockroach infestation, almost always the judge is not going to determine that the tenant did not owe any rent, but rather the judge is going to provide the tenant a very short period of time to pay the amount that the judge deems to be appropriate for that period of time. An omission or defect in these elements renders the notice defective. If a landlord proceeds with an unlawful detainer case based on a defective notice, the tenant can raise the defense in the answer. And in fact, because it's on the face of the complaint and essentially the unlawful detainer has not been properly pled, even if the tenant doesn't put the defect in their answer, the tenant can still win the case. It's essential that an eviction attorney drafts your eviction notice and the notices that have to be served with the eviction notice, which is determined by the type of property and the location of the property. And it's essential that the eviction attorney also prepares the unlawful detainer complaint and the summons and the other court documents that need to be prepared. Remember that if there is an attorney fees clause in the lease agreement that says that the prevailing party gets their attorney fees covered, then the losing party can be ordered to pay the prevailing party's attorney's fees. That means that if the landlord proceeds with an eviction case based on a defective notice and loses the case, then the tenant's attorney's fees are going to be the landlord's responsibility. This is important for the landlord to consider, and it's why the landlord needs very badly to have an attorney represent them in these cases. It's not worth the risk. Even if there's not an attorney fees clause, it's not worth the risk of incurring all of the filing fees and the time and energy spent pursuing a case until you know it's done right, which requires an eviction attorney. Not an attorney who practices 10 areas of law with unlawful detainers being one of those 10 areas. Those people do not know the intricacies of unlawful detainer law. Those people are not up to date on the constant changes to the local laws. They do not know what's happening in court every day. They do not have relationships with the judges. They do not have relationships with opposing counsel. They should not be representing you in an unlawful detainer case. And please do not hire a paralegal or a legal assistant to help you with your eviction case. It's not worth the money that you think you're going to save. And last but not least, if you are thinking, Madeline, this doesn't apply to me because my eviction case is not going to trial. I'm going to settle my case. That's great. And you're very likely correct because the vast majority of cases don't get all the way to trial. They often settle before trial, even if it's the morning of the trial or in the middle of a trial, but they most likely do settle. However, you will not get as good of a settlement without an attorney as you will with an eviction attorney. You won't. So don't decide that you're not going to make this investment in legal fees because you think that's going to be financially beneficial to you in the end. It won't be. You don't know the strengths of your case, so you cannot possibly negotiate a settlement that is most beneficial to you. For example, you don't know whether you have a viable habitability case that you can use as a huge negotiating tactic. You need an eviction attorney who only does eviction attorneys every day. It's just a select few of us who know, we all know each other and we are in court together and we know the judges and we know each other and we're up to date on the laws. Whenever there's a random attorney who I've never seen before, it's never good because, well, it's good for my client, but it's never good for the other side. Don't be that guy. Don't do it.